Namaskar. Today we will see about DK Basu's case. This present case are nothing but the guidelines by the Supreme Court of India in regards to arrest, custodial death and detention. Is a result of this case which enabled the judiciary to take steps and address the increasing number of days in police custody and lockups. The name of the case, DK Basu, respondent Union of India and State of West Bengal and others, quorum Kuldip Singh and Dr. A.S. Anand or Shri. Citation 1997 1 SCC 416 and 1997 SCC Criminal 92. Facts of the case. On 26 August 1986, the Executive Chairman, Mr. Dilip Kumar Basu of Legal Aid Services, West Bengal, a non-political organization, wrote a letter to the Chief Justice of India pertaining to some news articles in the Telegraph newspaper publishing events of death in police custody. The petitioner requested that his letter be accepted as a writ petition under public interest litigation category, as his letter addressed some important contentions. It was considered to be treated as a writ petition and the respondents were served notice. Mr. Ashok Kumar Johri, while the said petitioner was still under consideration, sent another letter to the Chief Justice addressing the death of Aligarh police custody of Mahesh Bihari of Kalkana. Both of these letters were treated as a writ petition. On 14th August 1987, the court issued a notice through order to all the states to come up with the suitable suggestions within 2 months. This led to the filing of the several affidavits in the response of the notice by different states including West Bengal, Assam, Orissa, Haryana, Meghalaya, Maharashtra, Manipur and Himachal Pradesh. The allegations were denied by the states of West Bengal. Dr. A.M. Sangvi, a senior advocate, was later appointed to assist the court as an amicus curiae. Then two issues are there. First issue, death of several accused in the police custody due to custodial torture by police. Second, a witness while arresting a person by the police. Then what was held in this case by the court? The court relied on various judgments delivered by Indian as well as foreign courts. It delivered that the state should act in a fair, right and just manner. Torturing an individual for extracting any kind of information is neither fair nor right nor just and is thus violative of Article 21. A crime suspect can be interrogated but cannot be tortured as it abuses his or her constitutional rights. The court, keeping in view of the already existing procedures laid down in Joginder Kumar vs. State of Uttar Pradesh, created a structured machinery to be followed in cases of arrest or detention. For punitive measures, it finally was of the view that many a time the courts faces the challenges of to satisfying the social aspirations of its citizens for whom the law is, and so the courts are obliged to act for the satisfaction of their aspirants. The families of the victims cannot be solaced by more punishments, and civil damages are a vexatious judicial process. In such cases, only a monetary compensation is a form of a redressal effective enough to satisfy the family of the victim if the victim was the sole bread earner of the family. The same view was taken into account in the case of Nilambari Behra vs. State of Orissa, held that adverting to the grant of relief to the heirs of a victim of a custodial death for the infraction or invasion of his rights guaranteed under Article 21 of the Constitution of India. It is not always enough to relegate him to the ordinary remedy of a civil suit to claim damages for the tortious act of the state, as that remedy in a private law indeed is available to the aggrieved party. The citizens complaining of the infringement of the right under Article 21 of the Constitution cannot be told that for the established violation of the fundamental right to life, he cannot get any relief under the public law by the courts exercising WRIT jurisdiction. The primary source of the public law proceedings stems from the prerogative writs, and the courts have therefore to evolve a new tools to give a relief in the public law by molding it according to the situation with a view to preserve and protect the rule of law. It was also held that for tortious act, the state is not protected by the principles of strict liability, for which a sovereign is guaranteed a humanity, but it must compensate the citizens whose fundamental rights, such as Article 21, is infringed. The court, while deciding the compensation, took the view that the citizen must be compensated keeping in mind of the compensatory element and not punitive. The object of the court should be to apply a balm to the wounds and not to punish the transgressor or the offender, as awarding appropriate punishment for the offense must be left to the criminal courts in which the offender is prosecuted, which the state in law is a duty bound to do. Then, why is this case significant in relation to criminal justice? This case is created, and a case, as it gives a piece of structured machinery, as earlier mentioned, for recording and notifying the cases of arrest or detention by maintaining the transparency and accountability. The following are the guidelines laid down in this case. First, accurate, visible, and clear identification and name tags. The police arresting and handling the interrogation must have accurate, visible name tags with their designations. A recorder must be maintained in the register for all those carrying out the interrogation. Second, a memo of arrest. At the time of arrest, a memo of arrest must be prepared by the arresting officer, which shall be arrested by at least one witnesses who can be a family member of the arrestee or any respectable persons of the locality from where the arrestee was arrested. Countersigned by the arrestee with a date and a time of the arrest. Third, a right to inform. The arrestee or a detainee has a right to inform anyone, friend or relative or other person is known to him as soon as possible of his arrest or a detention at a particular place, unless the memo of the arrest is attested by any such friend or relative. Fourth, notification by police. The police, with the help of a legal aid organization in the district and the police station in the area concerned, must notify the time, place of arrest, and the venue of a custody of the arrestee to his next friend or relative living outside the district or town. Fifth, the arrestee must be informed after his or her arrest or detention. The person must be informed and made aware of his right to inform his friend or relative. Sixth, diary entry. At the place of arrest, an entry should be made in the diary with the names and the particulars of the police officials in whose custody is the arrestee, along with the arrestee's name and the name of his next friend. Seventh, inspection memo. If the arrestee requests for him to be examined of any examining or existing major or a minor injury is present of his or her body at a time of arrest must be recorded, and this inspection memo be signed by both the police officer and the arrestee. A copy of the same should be provided to the arrestee. 8. Medical examination. A trainee doctor or trained doctor who must be on the panel of the approved doctors appointed by the Directors Health Service of the state or the union territory concerned should in every 48 hours examine the arrestee. The Director of the Health Services should prepare such a panels in all tahsils and districts. 9. Copies to magistrate. The magistrate must have copies of all the documents, including the memo of arrest, sent to him. Point number 10. The assistance of lawyer. The lawyer of the arrestee must be allowed to meet the arrestee during his investigation, interrogation, though not throughout the interrogation. And 11. That is last one. The police control room. There should be a police control room in all districts and the state headquarters which should have information regarding the arrest of a person in the place of its custody communicated to the control room by the officer causing the arrest within 12 hours of arrest, and the same information must be displayed on the notice board. Any failure to comply with above mentioned guidelines must not only make the concerned official liable for departmental actions, but will also be making him liable for punishment for contempt of court. The proceedings for contempt of court against such official will take place in High Court of the state concerned, having a jurisdiction on the matter. The guidelines are flow of Article 21 and Article 22(1) of the Constitution of India, and therefore needs to be followed strictly. This is in addition to the already existing constitutional and statutory safeguards and does not detract from various other directions given by the courts from time to time in connection with the safeguarding of the rights and dignity of the arrestee. So this is nothing but all about this D.K. Basu versus State of West Bengal, 1997, 1 SSC 416. Thank you for watching this video. Please like, share and subscribe this channel, and for others new, watch our channel. Thank you very much.